Hi, I'd like to introduce you to Doyles Construction Lawyers. Doyles Construction Lawyers has been established for more than 20 years and specialises in the construction industry. All aspects of construction contracts and documentation, planning and dispute resolution are covered by Doyles experienced staff. The staff are chosen for their commitment to the industry and their skill in understanding complex industry requirements and achieving commercial results for the clients. The client base reflects a diverse range of participants, from engineers, contractors, subcontractors and principals, and government authorities. We provide a wide range of training programs and seek to resolve clients' commercial challenges quickly, expeditiously, and achieving the results desired by the client. Hi, I'm Jim Doyle, and I'm here to speak to you today about heads of agreement. Heads of agreement are a valuable tool in terms of construction contracts because they often allow projects to start before they can, if they await formal documentation. However, there are risks and reward in using heads of agreement, and it's best that you understand them before you adopt them. Heads of agreement are often simply an informal note of what the parties intend to agree later. However, they can be binding and can constitute an agreement which is presently binding on both parties at a very early stage. You'll need to be sure then that the heads of agreement carefully set out all aspects of the arrangement which are important to you. A recent case in the Supreme Court of New South Wales demonstrates these principles, and I'd like to take you through that case today. The case is Malago and Ellis engineering, and the case demonstrated the complex arrangements which are often dealt with in heads of agreements. Malago and Ellis were stakeholders in a project which ran onto the rocks. The parties fell out after they'd signed the heads of agreement, but before they'd signed the formal documents. Accordingly, despite a mediation, they weren't able to come to agreement. The court at the first instance held that the heads of agreement were binding and that they could be enforced. However, the unsuccessful party appealed. The appeal court found two things. Firstly, that the heads of agreement weren't binding. They differed from the trial judge because they thought the heads of agreement were too general and didn't really provide for the specific requirements of the arrangements which the parties wished to enter. The appeal court also pointed out that the court has limited powers to order what's referred to as specific performance. Specific performance is an interesting remedy which compels a party to comply with their obligations at law, and particularly under a contract. However, the court said in this case, where there was a complex and interactive detailed agreement to be discharged, the court would not order specific performance. Accordingly, the unhappy party in this case thought they had a binding arrangement, but in fact it turned out that such was not the case, and of course they lost the benefit of the commercial arrangements and of course had to pay the legal costs. So it's important, if you're going into a heads of agreement, make sure that it states whether or not it's legally binding. And if it is to be legally binding, make sure it precisely sets out the terms, the arrangements the parties have entered into. You have to be careful in the preparation of heads of agreement in order to ensure that they properly represent the complexity of the deal between the parties. It's better not to rush a heads of agreement, but to make sure it's prepared carefully and properly represents a workable deal for all parties. Additionally, if the deal is such that it should be documented in formal documents without a heads of agreement, without any commitment by the parties to going ahead, with each party retaining its flexibility unto the end, then it's better to await the execution of formal documents. In any event, for contract managers, it's important to realise the benefits and the disbenefits of heads of agreement, and to watch carefully how your rights might be affected by those documents. Thank you very much for listening, and I recommend that you read the case carefully and apply it in your everyday contract management. Thank you.